Hello, everybody. Welcome. We're going to start our event now. Welcome, everybody. I hope you can hear me. My name is Stephen Wood. I'm the director of the Center for Law and the Environment at University of British Columbia, coming to you from the occupied territory of the Musqueam, Squamish, and Tsleil-Waututh peoples. I'd encourage everyone who's joining us from other locations to reflect for a moment about the territory they are on and who the traditional owners are of that territory and what that means for our proceedings today. Welcome to the first of 4 hybrid webinars on the subject, in their own words, plaintiffs and their lawyers speak about youth climate cases. This is part 1 about the case called Mathur and Ontario. This series of webinars deals with 4 leading youth climate cases from Canada and the US in which young people are demanding climate accountability and action from their governments. Each session in the series will delve into a particular case and will feature presentations from one of the youth plaintiffs in the case and one of their lawyers. So it's really a unique opportunity to hear directly from the young people who have the courage to stand up and challenge their government's records on climate change. The first event, today's event about Mathur and Ontario, is about a case in which 7 young people launched a legal challenge against the Ontario government and its decision to significantly weaken its greenhouse gas emission reduction targets. And they argue that this decision violates young people's and future generations' rights to life, security of the person, and equality protected under the Canadian Charter of Rights and Freedoms. This case has achieved multiple firsts. In November of 2020, the court recognized for the first time in Canadian history that climate change has the potential to violate charter rights, giving the youth the green light to move their case forward to a full hearing. And in September of 2022, it became the first children's climate case in the world to be considered and decided on the merits on the basis of a full evidentiary record. In April 2023, it became the first such case to be decided after a full hearing of the evidence. That's not to say after a full adversarial trial involving live witnesses and cross-examination. That honor is held by another of the cases that we're going to feature in our series, held against the state of Montana, which will be our 3rd hybrid webinar in this series. While Justice Vermette of the Ontario Superior Court ultimately dismissed the case, she made several key rulings in favor of the youth claimants. Their appeal from that decision was argued before the Ontario Court of Appeal last week. And on appeal, what the youth claimants are hoping to show is that not only is Ontario failing to act on climate change, but it is actively causing the increased risk of harm and death to Ontarians. We're joined today by one of the applicants in the case and one of their lawyers. I'll introduce first Shailin Wabagijig, who is one of the youth applicants, and then when she's done, I will introduce one of her lawyers, Danielle Gallant of EcoJustice. Shailin is Algonquin Anishinaabe, German, and Irish. She's a member of Temiskaming First Nation, Caribou Clan, and grew up in Rama First Nation. She received her honors degree from Trent University in Peterborough, Ontario, in Indigenous Studies and Philosophy. She worked for multiple nonprofits for 5 years with a focus on Indigenous knowledge, intersectional environmentalism, and climate justice. She's currently a full-time master's student at the University of Victoria in the Indigenous Governance program while living in Orillia, Ontario. And she is one of the 7 youth suing the Ontario government for their dangerously inadequate climate targets. Before I turn the microphone over to Shaylin, I would just note to people that there will be an opportunity to ask questions. We have people live in the room who can pose their questions live. We have microphones in the second row. So when it comes time, I might encourage people to come forward a little bit so that their questions can be heard. Online, there's a Q&A function in the webinar itself on Zoom, and you can start putting questions into the Q&A at any time. And when it comes time to take those, we will moderate those from here. And the only other thing I would say is for the people in the room, we are going to pass around an attendance sheet. If you'd be so kind to fill it out, we need that for UBC Finance Department requirements. Otherwise, they won't reimburse us for the cost of the lunch. So thank you very much for that. Thank you, Shaylin and Danielle, for joining us. And now I'll turn it over to Shaylin, and I will turn off the camera and the mic in the room here. Welcome.
Thank you. I'm so honored and grateful to be here with you all today. Thank you so much to everyone who's made this event possible, and for everyone who's listening in the room and online today. It's an honor to join you all. I'm going to introduce myself in my people's language, Anishinaabemowin, because that's our protocol for gathering, and those are the people I'm accountable to. So Shaylin Wabagishik Indigenous Nanode Wesawin Timiskaming Donjaba, Atik Indodem, Minjikning Indonjaba, Lakwangin Aki and Dada, Anishinabe Omamawinini Kwe, meanwhile German, Irish, and Dao. So I just said that my name is Shaylin Wabagishik. My family is from Timiskaming. I'm from Rama, and I'm in Lekwungen unceded territory in Victoria. I moved back to Victoria, so I'm an invited guest. We did a ceremony where I was invited into these lands in the traditional way, so it's a real honor to live and work here in these beautiful lands. Yeah, I'm a master's student. I'm in my second year, so we'll be graduating soon. And I'm also a research assistant, looking at the historical injustices and current realities of the University of Victoria. So supporting that research is also really exciting. And yes, I am also very honored and humbled and grateful to be part of this climate lawsuit with the other 6 youth and backed by Eco-Justice and Stockwoods and all of our incredible intervener organizations. So yeah, I'll get right into it. I first learned about climate change when I was pretty young in high school, and learned deeply about it through my work, my volunteering, and a lot more through this case, specifically the climate science. And I've experienced the impacts of climate change really mentally and emotionally, with experiencing climate anxiety and having existential crises, fear of having children, and another one, colonial grief, that's exacerbated by climate change. I just learned that word from a friend, and colonial grief really sums up a lot of the experiences that I've had, from losing our language and our way of life in harmony with the environment due to colonialism, and greed through capitalism. So, those are some of the impacts. And physically, I feel the impacts of climate change being outside in the sun. I used to go outside and not have to worry about getting a sunburn, but now I wear the most intense SPF protection. I also feel a change in weather patterns, and extreme weather events and that also impacts our cultural practices. This summer, I was out on the land, learning about Anishinaabe governance and education, and we really saw the changes in the trees and in the animals, in the medicines that we were picking when it was like really dry for long periods of time. That impacts the wetland medicines, and also, the species, the invasive species that really impact or exacerbated by climate change, and that one tree that's really important to us is being eaten by the emerald ash borer, and climate change is pushing it farther north to my territory, and that's threatening our ability to make black ash baskets, for example. So this also impacts me spiritually, is my spiritual connection to the world around me is tainted because the earth is sick and the earth is trying to heal itself. And I'm unable to live Minobamatsuin, which is our word meaning the good life. And this comes from our spiritual understanding of our place in the universe, as humble beings, that we rely on all of the other animals and the rest of the ecosystem to survive, right? And living in good relations with those is just good practice, so I'm unable to do that because of climate change and the way that the world is right now. And the Ontario government is contributing to that because they're going full steam ahead and continuing to develop and progress as usual, continuing colonization and capitalism as usual, and being open for business is their slogan. And they don't seem to realize that the economy relies on the ecosystem. I like to say that. They continue to disregard climate science and also Indigenous governance and self-determination in cases such as the Ring of Fire, which is a large mineral deposit in the heart of what's left of the boreal forest, and globally significant peatlands that the elders call the breathing lands, that's located in northern Ontario. So they have they were in relatively good negotiations with those nations, but they changed their negotiation tactics to just target individual chiefs through the band council system. And anyway, those communities are in court on this issue because they have not done their due diligence to consult in a good way. And the government also contributes to climate change when they want to open up the Greenbelt, for example, to urban sprawl. And the Greenbelt is a protected area of farmland and green space in southern Ontario. So Ontario just continues this pattern of wanting to burn fossil fuels and destroy the environment and approve projects that do nothing to change our dangerous climate trajectory. They repealed legislation, the Cap and Trade Act, and they set that low climate target, which is not in line with the Paris Agreement, as they have led the public to believe. So I decided to sue the Ontario government because their decisions today are impacting our lives and our future. The Ontario government is committing us to those dangerously high levels of greenhouse gases, and that decision is a violation of our rights. That decision is based on politics and economics, which is not based in the reality that we're facing an existential threat caused by those same colonial politics and economics. And the government is aware of the harm that their actions will cause on the people. And they set that out in their main mandate, their Made in Ontario climate plan. So the actions that I mentioned violates our right to life, liberty, and security, our Section 7 constitutional right, and discriminates against youth and future generations because we will face the worst effects of their decisions, those impacts in our lifespan. So from an intersectional lens, it discriminates worse on Indigenous youth because the damage caused by climate change also impacts our abilities to practice our cultures and our ways of life that are dependent on those lands and the waters and the beings we share them with. where our knowledge comes from those deep ancestral relationships over thousands and thousands of years. So although colonial courts have been exclusionary and violent towards Indigenous peoples, I decided that this is an important tool to hold governments accountable to their actions. And I want to know that I used every opportunity available and work with others, other incredible people to uphold environmental justice and fight for our future. And we need to bring those governing bodies in to remind them of their responsibilities. So through this litigation, I hope that the court will order Ontario to set new targets based on science, or the Paris Agreement or the IPCC report, and make a plan to reduce their carbon pollution in line with what's necessary to prevent catastrophic climate change and for the continuation of life. So this case has already supported climate litigation domestically and internationally, and brings attention to this issue and our rights to a safe environment, and for our governments to do something about it. And personally, this experience has really provided me and the other youth with a platform to speak our truth, which is really great because not a lot of times youth, especially Indigenous youth, have those platforms to speak to the public. And it has brought me so many incredible opportunities like this one to advocate for climate justice in ways that I would have never expected. So I'm really grateful. And yeah, a little bit about my experiences, like some highlights and lowlights. My experience really has been a roller coaster of like intensity and excitement and fear and hope all wrapped into one. Coming together with everyone, we really like built a family with the other applicants and the lawyers and the staff at EcoJustice, and all the people that support us. So it's created this strong network of people who believe that we can use our power and address this issue together. We launched the case in 2019, and we've grown so much through it together. The historic win at the Ontario Divisional Court after the motion to strike was the taste of sweet victory, and it made it all real and exciting that we made history, like we're doing good things. Something's really coming out of it, out of the hard work. And then the hearing in the Ontario Superior Court while navigating the pandemic was really interesting. We came together for the hearing on Zoom. I remember sitting in the EcoJustice office in separate rooms so they could each see each of our faces on the screen, and thinking to myself how ironic it was to be isolated 19 stories in the air in downtown Toronto while advocating for our charter right to a healthy environment. But you know, you gotta do what you gotta do to be safe. It was just very interesting. And then one highlight was the climate rally in Queen's Park, and being outside in the warm weather with inspiring music playing and children running around and artwork spread out on the lawn. And we each took turns addressing the crowd and sharing our truths and being like inspired by each other and our energy. That was a really great memory. And then just last Monday, we were in court for the first time in person. So that was a bit intimidating to be in such a space of white supremacy and colonial dominion, but to be there for such an important purpose and hearing our lawyers advocate so eloquently on our behalf was just healing balm to my soul, gave me hope. And the intervener lawyers, who only had 5 minutes each, were also really amazing. The lawyer from AFN, the Assembly of First Nations, spoke about our Section 35 rights that were also violated because the impacts that this climate target will have on our Aboriginal and treaty and inherent rights, in both the duty to consult, which they didn't, for their climate targets. So that was awesome to hear and bring that into the space. And as well, the lawyer from Grand Council Treaty 3 also argued that although we're asking for the charter to expand, they can draw upon Anishinaabe laws of protecting Mother Earth that has always been a law of this land. That made me cry, and I struggled to keep it together, sitting in the courtroom trying to keep a straight face, keep it together. But Maddie, my fellow applicant, she held my hand until I pulled it together. And, I really wanted to be there to hear all of what they had to say. So it subsided, and yeah, it was really powerful. And the lawyer for Our Kids was also really impactful, how they argued for the right of the child that's invoked with climate targets, because it's our right to live a full life, right? And climate change threatens that. So that was a very powerful argument for our future as well. Yeah, so in closing, I pray for the world that we're all creating together. That's a choice that we all have in our everyday actions. And there's also this little story that I learned recently where a man asked an elder, "How do you change the world?" And they were walking outside, and she threw a pebble into the water, and she said, "That's how you change the world. You start with your smallest circle, and it expands out from there." And what we do really ripples out into the world, and it's powerful to make such big waves in situations like this climate lawsuit. So yeah. Miigwech kinawia. Thank you everyone for listening. Webini, Nikanagana. Take care, all my relations.
Shannon, thank you so much. I want to just let you know how much we appreciate that. I hope you can hear a round of applause from inside the room. We don't have cameras facing the room. I apologize for that. It must seem a little bit impersonal and disembodied for you. But yeah, we're so grateful for you sharing your personal experiences and your courage with us. I'm going to now introduce Danielle Gallant, a lawyer with EcoJustice, which is Canada's largest environmental law charity. As a member of the EcoJustice climate change team, Danielle has worked on several prominent constitutional cases, including the references regarding the Greenhouse Gas Pollution Pricing Act and this Mathur and Ontario case before the court, which is now, as we know, before the Court of Appeal. Before that, she worked at the International Criminal Tribunal for the former Yugoslavia. She's a member of the Quebec Bar and the Law Society of Ontario, holds a licentiate in civil law and an honors bachelor in international development and globalization from the University of Ottawa, where she graduated summa cum laude. That's as good as it gets. I think that's the way it literally translates from Latin. And also completed her master's in global sustainability and environmental law, the LLM, from the same university, during which she focused on the intersection between environmental justice and human rights and on charter-based climate change litigation. EcoJustice, in case you're not familiar with it, uses the power of law to defend nature, combat climate change, and fight for a healthy environment. Its strategic public interest lawsuits and advocacy lead to precedent-setting court decisions and law and policy that deliver lasting solutions to Canada's most urgent environmental problems. And as Canada's largest environmental law charity, EcoJustice operates offices in Vancouver, Calgary, Toronto, Ottawa, and Halifax. Over to you, Danielle.
Thank you for the kind introduction. I'm just going to go ahead and share my PowerPoint. All right. Just want to make sure, maybe Shay, you're the only one I can see. So if you're seeing my PowerPoint, can you just give me a, yeah, awesome.
We are seeing it.
Great, wonderful. That's the first step. So again, thank you for the kind introduction. I was meaning to go through some of those details, but I won't need to. I will mention that I myself am located in the Ottawa office of Eco-Justice, and I'm situated on the traditional and unceded lands of the Algonquin and Anishinaabe people. And as it shows at the bottom right of the PowerPoint, the Eco-Justice office in Ottawa is a bit particular in the sense that we operate in partnership with the University of Ottawa, and also provide a clinic class to students as part of that partnership. And so I'm here today to talk about, obviously, the Mathur versus Ontario case. And we just got these really great pictures of all the applicants taken during the days leading up to the hearing. And so looking very cool right here. And so the items that I'm going to cover, just a little bit of brief context about, why this case is being brought and kind of what the global context for it is. And then delving into the case, we'll talk about what it's about, even though both Shay and Professor Wood have already mentioned a little bit about that, and some of the key moments throughout the case that have also been mentioned: the motion to strike, the merits hearing, and the decision that we received, and then the appeal hearing, and getting us up to date and asking the question, what happens now? And then sort of zooming back out, looking at the broader movement that it's a part of in Canada, and then reflecting my own reflections on working on this case as a lawyer, and then obviously opening up to questions. And I also just wanted to give a shout out to Sophia, who drew this poster as part of the rally that we did surrounding the merits hearing. So she's very talented. All right, so the context in a nutshell of this case is that there's this global consensus that we as a planet have to keep global warming below 1.5 degrees Celsius in order to avoid cataclysmic levels of climate change and climate impacts. And, we're starting to see the impacts of these. They're only becoming more visible, but we're talking about things like extreme heat, wildfires, flooding, the spread of infectious diseases, and all sorts of climate-related impacts that will cause an increased risk of harm and death to Ontarians and to many people throughout the world. And this idea that we have to keep the world 1.5 degrees is endorsed by world governments through the Paris Agreement and many other agreements since that have continued to endorse this idea, and also is based on the scientific consensus set out in the reports of the Intergovernmental Panel on Climate Change, or the IPCC. So we have this convergence of the political consensus and the scientific consensus in terms of what we must do collectively in the world. And as I just mentioned, we're continuing to see, more visibly the impacts happening. They're starting to happen maybe in places where they hadn't happened before. Being in Ottawa, I'm not used to experiencing wildfire smoke, and we're starting to get more frequent tornadoes and extreme weather events of many different kinds. And we also know that 2023 was the hottest year on record. And so we're also just starting to witness more and more that what the science has said is coming to pass. And then on the other hand, we have the fact that youth and many other communities who are at the front lines of climate change impacts are the ones who are leading the fight against climate change by, protesting against their governments in the streets, but also bringing their governments to court. And this is happening around the world. And just to illustrate this a little bit, here are two graphs from a recent report on global trends in climate litigation. And so we can see that in recent years, and especially since 2015, the year of the Paris Agreement, there is a surge in terms of climate cases being brought around the world. There's a lot of them that happened in the US, but as you can see in the second graph, more and more cases are happening in other jurisdictions, and ensuring that, multiple actors are being targeted. And so, this case is part of a broader movement of climate litigation across the world, attempting to hold governments and other actors accountable. And increasingly, those cases are winning, and especially in kind of very, large-scale cases like the ones that have been brought in the Netherlands and Germany, Colombia, France, many places throughout the world. And so it's a very exciting movement to witness and also be a part of. So that brings me to what the Mathur case is about. And so you've already heard a little bit about this, but I'll go over the basics again. It's an application being brought by 7 youth, including Shay, who come from across the province of Ontario. And they're bringing the case on behalf of Ontario youth and future generations. And what that means is that they're bringing the case in the public interest rather than necessarily on their own behalf. And the case is against the provincial government of Ontario. And what they're specifically challenging is Ontario's decision to cancel its previous GHG emission reduction targets and to replace those with one target for 2030 that is completely out of line with science. And they did this through a piece of legislation. And the practical result of having done that is, first of all, a net increase of emissions between the two targets of 200 megatons, but it also aligns Ontario's target with catastrophic levels of warming well beyond 1.5 degrees. One of our experts opined that if every jurisdiction in the world took the same approach as Ontario in terms of setting their target, the world would be on track for 3 to 5 degrees of warming, which is a truly catastrophic level of global warming. And so that is really the piece that is being challenged in this case. And the legal basis for it, as Shay was mentioning, are sections 7 and 15 of the charter that protects our rights to life and to security of the person, and then to equality. And that is because Ontario's target is increasing the risk of physical and mental harm and death from all those various impacts I've already mentioned. And we know that youth and future generations are going to be disproportionately impacted because, first of all, young people under 18 are more vulnerable to physical health impacts, and young people under 30 are more vulnerable to the mental health impacts. And so there's a clear relationship between how old you are and how vulnerable you are to climate impacts. But young people will also live longer into the future as these impacts will continue to worsen in frequency and severity. And as Shay was mentioning, Indigenous youth and future generations also have intersecting vulnerabilities. And so youth and future generations are already disproportionately impacted, and then you add on top of that the layer of being Indigenous, and that's a group that's truly on the front line of these climate impacts. And what we're seeking in this case, legally speaking, is first a declaration that the target is unconstitutional, and also an order that Ontario set a new science-based target consistent with its share of global GHG emissions and to revise its climate plan accordingly. We're basing this case on an extensive evidentiary record, including many authoritative reports from the IPCC. The IPCC is considered kind of like the global consensus baseline in terms of the science. It's very authoritative. It includes kind of a line-by-line review of the summary by world governments. So, we've seen climate cases around the world rely on IPCC evidence, but we also have the benefit of many government reports from Ontario itself and from Canada detailing the harms that are expected to occur. And on top of that, we adduced 17 expert reports on different topics, including, explaining the science of climate change, setting out all the ways in which the impacts of climate change will affect Ontarians, and then finally, how you can evaluate the target on a global scale against Ontario's fair share of the global carbon budget. And then finally, we put forward, each of the applicants were able to put forward an affidavit establishing their public interest standing, showing why they are so concerned about climate change and what they have each done in their personal capacity to fight back against climate change. And as has already been mentioned, we reached a key milestone in this case when we survived a motion to strike. And that is essentially an attempt of the government to try to have the case thrown out before it is even heard on its merits. And this is something that's happened in every climate case to date in Canada. So it's not a surprise that this happened. It's one of those hurdles that all these cases have to get past. And thankfully, we won at the first stage of that motion. Justice Brown rejected it in its entirety, concluding that Ontario's target is reviewable for compliance with the Charter and that the application is justiciable because it challenges very specific government action compared to some other cases that were a bit of a broader approach. She found that the claims are capable of scientific proof. They're not based on unprovable speculations. There's tons of science here that can help us prove this case. And Ontario had claimed that this was a case based on positive rights. And at least at the motion to strike phase, she found that that was not determinative, even though she didn't decide either way if it was a positive rights case. And the fact that it was a novel new type of case does not mean it should be struck. And finally, she found that the applicants have standing on behalf of future generations, which is a huge key finding, which I've understood is quite novel, even on the international scale, to have this standing to speak for future generations. And so that brought us to the merits hearing, because not only did we win the motion to strike, Ontario sought leave to appeal that decision, which was denied, and confirmed that this was the first charter-based climate case in Canada to move on to a full merits hearing. And this means that the court was able to look at all the evidence that we put forward and come to a decision on that basis. And as Shay was mentioning, the hearing was accompanied by a press conference and a huge rally, which we involved members of the public. It was a really wonderful moment. And we also received heightened media attention, just given the historic nature of the hearing. Unfortunately, in April of 2023, we received a decision from Justice Vermette of the Superior Court dismissing the application. Though the overall result was a loss, there were many good things within the decision, positive findings from our point of view. First of all, she did endorse the key facts of climate change. There was no debate that climate change is happening, and it is and will continue to cause those harmful impacts to Ontarians. And that on top of that, it has disproportionate impacts on young people and Indigenous peoples. And she also endorsed the key fact that in order to keep global warming to 1.5 degrees, the world has to reduce its emissions as a whole by 45% below 2010 levels by 2030. And just to explain the difference here in terms of the math, Ontario's target is based on a 2005 base year. So if you put them on the same level, Ontario should be reducing its emissions by a minimum of 52% below 2005 levels by 2030 compared to its 30% target. Justice Vermette also accepted that the case is justiciable, and what that means is that it's an appropriate legal question for a court to weigh in on. It's not too political in nature. Because again, the challenges is to very specific state action and legislation, and the relief sought does include things like a declaration of unconstitutionality, which courts are able to grant. And she did, however, find that the question of Ontario's fair share of the global carbon budget was not justiciable because it couldn't be determined by scientific evidence and does not have a sufficient legal component. She also found that this case raises positive rights, disagreed with how we had framed the issue that by setting the target, Ontario's authorizing, incentivizing, and facilitating, and even creating itself the very level of GHGs that is causing harm, finding that it's instead the fact that Ontario did not aim sufficiently high when setting the target. She did, however, disagree with Ontario's point that the target was meaningless because it is meant to guide and direct subsequent state action. But ultimately, the applicants don't seek to be free from the target. They just want a more restrictive one. But she did find that the applicants made a compelling case that climate change presents special circumstances that can justify positive rights under Section 7. So she continued her analysis without kind of coming to a complete finding on this point because she didn't have to. She did find that the target is causally linked to the harms because it falls so severely short of the scientific consensus on the required climate action. And so by not taking steps to reduce GHG further, Ontario is contributing to an increased risk of death and to security of the person for Ontarians. And the mere fact that other countries contribute to climate change, and maybe more so than Ontario, does not diminish Ontario's own role. Its emissions may be numerically small, but they are measurable and they're not speculative. And finally, the Section 7 causation standard has to be sensitive to the context of the case. And in this case, in terms of climate change, we must consider the fact that there's a collective action problem where every jurisdiction could point to others and say, I don't need to act because others will. And that will simply not solve the issue. And this is where the case, unfortunately, failed at the Superior Court level, is that Justice Vermette found that the target is not contrary to the principles of fundamental justice. And that's just the second part of the Section 7 test under the Charter, finding that because the target goes part of the way to reducing emissions, it can't be arbitrary, and that gross disproportionality can't apply in a positive rights case. We'd also put forward a new principle of fundamental justice that she did not accept. On Section 15, she also disagreed that there was a violation because she didn't find that the impact on young people was being caused by the target. She found that it was rather by climate change writ large, and that the Charter does not impose a positive obligation to remedy inequalities. And finally found that the effects were not, in fact, based on age, but rather this idea of temporal distinction, the passage of time, and that impacts of climate change will be experienced by everyone in the future. And so the ultimate result was that the application was dismissed, but on several occasions, Justice Vermette seemed to leave the door open for perhaps the Court of Appeal, saying that it would be difficult not to be sympathetic to the concerns expressed by the applicants, and that her finding was based on the current state of the law, which may evolve. And also expressing that there's likely a different framework of analysis for positive rights claims under Section 7 that would need to be developed. And so fairly immediately after this decision came out, the applicants all agreed to appeal the decision. They weren't done with this case just yet, needed to keep fighting, and essentially raising most of the points that I just mentioned, errors in treating the case as raising positive rights, or if it does raise positive rights, in assessing the claim accordingly, failures to properly consider the principles of fundamental justice claimed under Section 7 and in assessing the Section 15 claim, and in concluding that it was not possible or justiciable to determine Ontario's fair share of the global carbon budget. And so these were all questions that were, again, raised on appeal. And as Shay mentioned, one of the really exciting and important parts of the appeal was the fact that 12 groups were granted leave to intervene. Interventions are really important to ensure that, especially on issues like this that are important and complex social issues that impact a lot of people, that various perspectives are being considered. And so, we had groups representing medical professionals, representing groups of parents and grandparents, representing different Indigenous communities, environmental groups, international law groups, civil liberty groups, many different groups. And they did each only have 5 minutes at the hearing, but I think they made really impactful submissions that added a lot of nuance to the issues in front of the court. And so, as Shay mentioned, just last week, on January 15th of 2024, the applicants and the lawyers had our first real day in court of the Ontario Court of Appeal. So I think that was a really perhaps nerve-wracking, but also amazing experience to have everyone there in the courtroom with the judges and the lawyers. And Ontario's approach to their arguments was very similar to how they argued at the Superior Court. They were essentially defending Justice Vermette's decision that she was correct to dismiss the application, reiterating certain arguments that they'd made about Ontario's emissions being too small to really matter on the global scale, and that its climate target is essentially meaningless because it doesn't impose any legal obligations or duties on anyone to take any action. So that was a whirlwind tour through what has happened so far. We get this question a lot: what happens now? What happens next? And now we wait. And so it's that difficult waiting game where, we're just anticipating when we'll get the decision. We'll likely get it within a year. It could be released as early as in 4 months, but we won't know that in advance. And no matter the outcome, it's quite likely that this case will continue on to the Supreme Court of Canada. That's obviously something that we'd have to discuss with the applicants before confirming, but these types of cases often do go all the way. And in the meantime, we still have our work cut out for us, raising awareness about this case and fighting climate change in other ways, other cases, other initiatives. And so the work is never done. I did want to mention that the Mathur case is part of a broader movement, both internationally, but also in Canada. There have been several cases brought against other governments in Canada. The first 3 on the screen were brought against the federal government. Environnement Jeunesse was a class action case filed on behalf of all Quebec youth 35 and under. Unfortunately, that case was not able to overcome a preliminary hurdle to certify the class action. So that case is now closed. La Rose is a case being brought again on behalf of, I believe, 15 young people who come from throughout the country because of the federal government's actions and inactions causing the climate crisis, also based on Section 7 and 15 of the Charter. And Meets Yeek is a case being brought against by 2 Wet'suwet'en and House groups, also against the federal government on similar grounds than La Rose. Unfortunately, those 2 cases were struck out through a motion to strike at a preliminary level, but they very recently heard from the Federal Court of Appeal that that decision has been reversed, and they've been allowed to proceed on the basis of their Section 7 claims. So that's very exciting that we now have other cases proceeding in Canada against the federal government. And the final case at the bottom is another provincial level case, the Dykstra versus Saskatchewan case, being brought against both the province and I believe a Crown corporation involved in power generation in the province. And so there's other developments to watch in this space, other cases moving forward. And we know that every time that we get a win and add to those building blocks in terms of our own case, that also helps other cases going forward and vice versa. And so, we really wish all of these plaintiffs the best as they move forward. And then finally, if I can allow myself to reflect a little bit on my experience working on climate cases as a lawyer, I think it's been incredibly rewarding. This is one of the first cases I've been involved in at all. And so it's been a huge learning experience. Working on these types of very new cases that don't have a lot of applicable precedent to draw from can be very challenging and can require a lot of legal creativity, which is not words I think we're really used to hearing in the legal sphere, but really trying to have a vision of what we could achieve and how we could get there. One thing I had not fully appreciated was how much science I would need to understand, and not having a scientific background, that was quite a struggle for me. But I actually think that it meant that I could look at our evidence with a critical lens and say, do I understand what people are saying? Is the judge going to understand? And how do we communicate that in our legal arguments? And there's the other fact that in environmental law, the science and the evidence is constantly shifting under our feet. It's constantly being developed. And so that can be difficult to stay on top of these new developments. It can also be challenging to go up against governments or large corporations. As a not-for-profit, there can be a bit of a David versus Goliath dynamic, but I think that the great work that we do at Eco-Justice, we can power through those types of dynamics and still establish really important legal precedents. And then finally, I think it's very impactful to feel like we're part of a global movement, and to know that any success that we have here will help people in other countries or in other jurisdictions in Canada. And so there's a lot of solidarity internationally for these types of cases, and I appreciate that a lot. And finally, it's just so rewarding to work with amazing young people like Shay. It's been one of the highlights of my career, even though I'm pretty early into my career, but you know, I've learned so much from working with them. I'm incredibly proud of them. I love to hear them speak, and I love to hear about what they're doing outside of this case. So that part, you know, I think sometimes can keep us going, even in moments when this gets difficult. So I love that aspect of the work. So I'll stop there, and I'm happy to answer any questions that you may have. Thank you.
Thanks very much, Danielle. A little round of applause for Danielle in our room. So we have time for questions. I'm just going to say to the folks in the room, if you're ready to ask a question, would you mind coming up to the second row, just like in the old days when people would walk up to the microphone? That'll just make it easier for everyone to hear. And Kylie, who's in the room with us from the Center for Law and the Environment, is going to moderate online if there's any Q&A. Do we have any in the queue? Online? Okay, we have one here in the front row. Do you mind introducing yourself when you ask your question? You don't have to touch it, you can just speak.
Thank you. Thank you so much for the sharing. I am Liam, a first year law student at Adler. I have a question about the litigation strategy. For example, you mentioned there are cases at the provincial court or federal court and against the different government entities for different policies. So when you decide to sue the government, or as a lawyer, when you decide to take a case, what factors do you consider, like whether it's more possible to be heard in certain jurisdiction, or it's more likely to have a challenge against certain types of government action? Thank you.
Yeah, I can take. I did. Yes, that came through very clearly. Thank you, Liam, I believe. I think it's a very good question. There's a lot of factors that go into why you would choose to litigate in one jurisdiction versus another. You could look at, on a very practical level, you know, what the precedents have been at various courts to, even though there may not be perfectly analogous cases, you know, looking at Section 7 and 15 charter jurisprudence on other matters. You know, there can be very practical considerations, like the fact that Ontario does have a route to bring these applications, which basically means that you get to avoid a lot of the evidence required in trials. There's no viva voce live evidence. None of our applicants had to go in front of the court and speak live in front of the court. It was all done through documentary evidence, which can really simplify the process and allow the process to go more quickly. So we had the advantage of having access to that in Ontario. More strategically, zooming out a little bit again, Ontario did something that not a lot of governments in the world have decided to do, which was actually to move backwards on climate change at a time where global scientists are telling us we have to do more, not less. And so I think that the reality of Ontario not only setting a scientifically inadequate target, but also repealing its previous and more ambitious targets in order to do so, you know, is a set of facts that doesn't exist in other jurisdictions. And I think is kind of a key element of this case that needed to be called out. I don't know, Shay, if you wanted to add anything. Great, just wanted to be sure.
Can I pose a question? Is there one lined up in the online queue? I guess this question is mainly for Shay. I'm really curious if you've had direct contact with young people around Canada or in other countries who are plaintiffs or claimants in other lawsuits like this, and if so, like, what's that been like?
Thank you for the question. I believe I've had the opportunity. We haven't had any events or anything that's brought us together, and I think that would be really beautiful to support each other, like on a personal level. We have had some indirect communication with the youth in Montana. So we've shared our sentiments of support for them, that we understand, what they're going through, like the emotional labor that it really takes and like the courage. So yeah, although we support each other from a distance, no, we haven't had the chance to connect yet, but that's a good idea. Maybe we should work on that, eh, Danielle?
Yeah, no, I like the sound of that. I can say at the lawyer level, there's a network of international lawyers working on these cases around the world. And so we've been included as part of that network, but I agree. I think there should be more opportunities for the litigants involved, and especially youth litigants, to speak to one another, collaborate. I think that's an excellent idea.
I would just, if you have one, come on up. While you're coming up, I'll just react to that. What you said about emotional support and the courage that it takes to do what they're doing was so much on display in the trial in Montana, which was televised. And I don't know if anyone had the opportunity to see that, but the plaintiffs in that case testified on the stand, and their testimony was so clear and so powerful, but also you could see so moving and difficult for them to give. So I'm not sure if if the recording of that trial is available, but if you have a chance to look at it, it's really remarkable. And we have another question in the room.
Hello, my name is Calvin. I'm a second-year student here at the Allard School of Law, and my question was related to your point on seeing this case head towards the SCC eventually. I was hoping maybe you could elaborate more on that, and is that something that's kind of nerve-wracking, that maybe if this goes to the SCC and they say that a Section 7 or a Section 15 claim can't be used for these youth climate cases, does that potentially close the door on a lot of these cases? And sort of what are your thoughts as this case goes up the judicial ladder?
Yeah, thanks, Calvin. That's a great question. I mean, I think from the start of this case, it was always something that we expected or anticipated to have to go on to an appeal and then probably on to the Supreme Court. See, we've just lost Shay, so hopefully she'll be able to get back in. I do think that obviously continuing on to the Supreme Court of Canada raises the stakes quite a bit on this, but I think that, it's not something, obviously it's something we would discuss with the applicants involved before deciding, but I think it's something we've always expected to be the next step, no matter what the Court of Appeal says. I also think that, it's likely that the other cases are also headed there. And so in a way, it's a little bit inevitable in these types of climate cases that the Supreme Court will, one day or another weigh in on this issue. And I think all that we can do as lawyers involved in this case is, really do our best effort in order to get the best legal precedent that we can for other cases. And so, while we can't fully control the ultimate findings that are made on Section 7 and 15 of the Charter, I think we have, from the Ontario Superior Court, some really excellent findings of fact to be able to build our legal arguments off of. And that was, I think, one of the main parts of this case, and something that wasn't a guarantee that there'd be a full endorsement of climate science and the impacts. And so I think now that we have that, as the first time that a case like this has looked at the evidence, I think that will help other climate cases move forward as well, on similar bases. And I would also say, each of these cases have been launched on slightly different premises. The La Rosa and Mizzi cases, for instance, are really based on more of a global attack type case theory, where they're going after a broad swath of government actions and inactions. And so even if our case fails looking at the target in particular, there's so many ways in which governments contribute to the climate crisis that, that doesn't, I don't think, mean that it will shut down every single way that you could challenge government action on climate change. And so, while we hope for the best, even if the worst happens, I think that there would still be openings for other cases to be brought just on other ways of approaching the issue.
It's good to see you back, Shay. Do you have any feelings about what it would be like to go up to the Supreme Court of Canada?
Yeah, my apologies. My laptop died, so I had to run and grab my charger. Yeah, I expected that we would stay, well, personally, I would stay in this case and see it through to the very end because I just believe in it so much and think that there's nothing really more important that I could be doing right now. So yeah, I'm in it. I'm in it to win it, hopefully. Yeah, like it's kind of intimidating being in those kinds of spaces, especially like being in the highest court in Ontario just last week. It was, yeah, a really like kind of scary experience. So I do expect the same kind of reaction if and when we get there. But yeah, it's so important. So it's all worth it in the end.
And maybe if I can just build on that, I also think that it's important to recognize that there's different ways of winning when you bring these types of cases. And obviously what happens in the courtroom is very important, can set very important legal precedents, but there's also everything that's happening outside of the courtroom. And there's, bringing attention to this issue, informing the public about what the Ontario government is doing. And so I think even if we lose from a legal standpoint, and again, even if we lost at the first instance, there were a lot of really good things that we can draw from in climate litigation moving forward. But even if we continue to lose, I think that there's many other things that this case has achieved and will continue to achieve and that are worth doing.
Yeah, the Philippine lawyer, Tony Apoza, who brought a lawsuit on behalf of his children and his friends' children way back in the early 1990s, in which the Philippine Supreme Court ultimately ruled that they had standing to sue on behalf of all Philippine children and future generations. So Danielle, that's one of the very few explicit legal rulings around the world saying you have standing for future generations. He always says, you really can't lose in the ultimate sense in a court of law, because the difference between a court of law and other public forums is that you have the right to tell your story. Once you get in through the courtroom door, you can tell that story, and it has to be listened to, and it has to be considered on the basis of evidence and objective legal standards. And so that's always a victory. And also, as you say, even a legal defeat in the courts can turn into success in public opinion, and it can drive change at the legislative level. It can change governments and so on. There's another question, but do you mind coming on down? I feel like it's The Price is Right now.
He's on.
Yeah, you're good.
Perhaps I can turn Professor Wood's comments just that into a question that I was dwelling on throughout your presentation, particularly concerning Shay's comment about entering the courtroom as a colonial institution. And I'm hoping that you can discuss a little bit more about the medium through which you chose to pursue these claims. One, perhaps from the perspective of this colonial institution that you're entering, as you said, Shay, and then also pursuing this claim as a public law, the mechanism or the medium of a public law challenge.
Yeah, I'm not sure if that was a question more for myself or Shay. I don't know, Shay, if you had any comments or you want me to go first? Yeah, okay, awesome. I mean, I think it's important to recognize the inherent limits of courts and particularly, how they have in the past. I think Shay used the term violence. I may be paraphrasing, but that there has been real harm done through the court system in the past. That being said, I think that they do remain a very important tool that we have, particularly as the climate crisis becomes more and more dire, and other ways of trying to move governments to act have not worked. I think that courts can still remain kind of a great forum of last defense, and also because and I think this speaks maybe a little bit to your question about why advance this case in public law, and particularly on constitutional charter rights, is that if you do secure precedent just against the Ontario government, that also sends a strong message to other governments in Canada who are also can be held accountable through the charter that, your residents might also sue you on the same basis. And so, I think the value of a legal precedent that's based on the charter is perhaps in this instance something that can be a very powerful tool to affect change. Recognizing that there are inherent limitations to the court system. I know Shay had mentioned that the Assembly of First Nations, for instance, had argued various points about the honor of the Crown and the duty to consult on the target. And at the Ontario Superior Court, they made similar arguments, and those were completely disregarded in the decision. And so there's certainly there can be inherent obstacles to bringing certain pieces of the claim forward, even in terms of what we advanced as the applicants, as lawyers for the applicants, the intersecting ground of being both a young person or a member of future generation and being Indigenous was something that was also completely disregarded in the decision. And so I think it's important to still keep raising these points and keep attempting to move them forward, acknowledging that, there's a chance that they may not be listened to, but it's still very important to move those perspectives forward. I feel like that was a rambly answer that I hope provided a bit of insight into what was asked.
Mm-hmm. Yeah, I hope that I understood the question properly too. And thank you for that, Danielle. And thanks for the question. Yeah, like for me, it's very important that I'm able to use all of the tools that are available. And, the courts have recently made positive decisions for Indigenous rights. So I know that it has an impact on people today, the decisions that are made in those courts. And I'm hoping that this decision can at least slow down the impacts of climate change and have the courts hold their governments accountable, and that we can hold the governments accountable for their actions. So yeah, although I don't fully bow down to the superiority of the Crown, like I'm researching Indigenous governance and I acknowledge Anishinaabe sovereignty. I can also do this at the same time because I'm also a Canadian citizen, by choice or not, so I just feel like I have to use all the tools available because I am educating myself. I do go out in the street and protest. I, do everything that I can. So this is just another tool in my toolbox that I'm so honored and privileged to have the platform and the opportunity to bring forward and speak and represent other Indigenous youth and other people who share the same fears and, wanting to hold Ontario especially accountable to, the effects and the impacts that they have on the climate. So, yeah. Thank you.
Thank you so much. We have time for one last question from Avery, but you got to come all the way down. Right there at the corner is where the mic is.
Hi, hi, sorry. My name's Avery. I'm also a student at Allard. I noticed, Danielle, on your slides that Urgenda was an intervener in the case. And I'm curious how they went about translating findings from a Dutch jurisdiction, which is, I believe, civil, right, into the Canadian context, and also more broadly, what you see as the role of other international climate cases on influencing either the arguments you bring forward or judicial reasoning in the Canadian context.
Yeah, another excellent question. Thanks, Avery. You have keen eyesight. That was Urgenda that intervened in collaboration with Greenpeace, because as of yet, Urgenda does not have any Canadian-based lawyers, and so they would not have been allowed to provide arguments in our courts as non-Canadian lawyers. I do think that at the Superior Court, at the Merits, and at the Court of Appeal, we had interveners at both times providing really helpful submissions on international cases on various pieces. And I think that even though we're talking about different legal systems, there's often, very different rights that are involved. Sometimes there's explicit recognition that there are positive rights and that there's duties owed to people on the basis of those rights. Despite the fact that there may be differences, there's really important similarities. And I think certain key facts, like the fact that courts around the world have acknowledged that every emission causes measurable harm, and have rejected multiple governments' attempts to say our emissions don't matter because they are too small. And I think that especially in countries that have very similar emissions levels to Ontario, including the Netherlands, it is also very impactful to show, like on a factual level, two jurisdictions with very similar emissions, you should come to the same conclusion as other courts have around the world. And I think that you can refer to how other courts have adjudicated this for very basic premises, like the fact that courts can weigh in on these issues, and they have. And courts can, for instance, look at carbon budgets and look at how those are allocated across the world and hold a jurisdiction accountable for not having a target that keeps it in line with their share of the global carbon budget. And so while there's, maybe not a direct legal transferability in terms of a precedent, there's those various pieces that can be relied upon. And Justice Vermette of the Superior Court actually cited to Urgenda and several other decisions in her decision. And so I'm hoping that as we proceed onwards, courts will continue to rely on those cases for those kind of very basic premises, which shouldn't be controversial at this point in time.
I'd actually like to give the last word to Shay, if you're willing. I just wonder, Shay, what message would you like to leave young people around the world with at this point? What would you like to say to them?
Thank you so much. I'd like to say that you have power and your voice matters. It's up to us, as we are the leaders of today, and we are learning about the world and the way that the world is, and we all see it. It's not a good place right now with everything that's happening with the climate and genocide around the world. We see that, and it is our responsibility to challenge the way that it is. So I encourage you to continue using your voice and taking your power. Like, you have that power, no matter what people say, that you're too young, your voice doesn't matter. I've been told that so many times, like that, you're young, what do you know? But no, like, we have so much power in our voice, and people do want to hear what we have to say. So speak up. Yeah, and stand up. Yeah. Thank you.
Thank you, Miigwech, Lechka. Join me in thanking Danielle and Shay. That brings today's event to a close, but please tune in at the same time for the next 3 Wednesdays when we're going to be hearing from plaintiffs and lawyers in the Canadian LaRose case, the Held case from Montana, and the Juliana case from the United States Federal District Court. Thanks very much again.
Thank you for having us. Bye.
Thanks.